Section 4, Legal Hotline Q&A, Arizona Fair Housing 101, Learning from Real-World Fair Housing Questions. Sarah had been practicing real estate for several months and was beginning to feel much more confident. "I think I'm finally starting to understand fair housing," she said as she walked into David's office. David laughed. "That's exactly when the interesting questions begin." He reached into his desk drawer and pulled out a folder. Over the years, brokers receive hundreds of fair housing questions from agents. Some are straightforward, while others require careful legal analysis. Let's look at a few situations that closely resemble questions brokers receive every year. Sarah smiled. "I have a feeling these aren't going to be easy." They rarely are. Legal hotline question number 1, age-restricted communities and a disabled child question. A buyer wants to purchase a home in an age-restricted community. The buyer's adult child has a disability and must live with the buyer to receive daily care. Can the community refuse to allow the disabled child to live in the home because of the age restrictions? Answer: probably not. David explained that many age-restricted communities qualify for exemptions from certain fair housing provisions relating to familial status. However, those exemptions do not eliminate a housing provider's obligation to make reasonable accommodations for individuals with disabilities. Arizona courts have addressed this issue. In Kennedy versus Prescott Canyon Estates Homeowners Association, the court concluded that refusing to make a reasonable accommodation for an underage individual with a disability violated fair housing requirements. The lesson, David explained, is that disability accommodations often require a different analysis than age restrictions. A community should never assume its age restrictions automatically override fair housing obligations. Broker tip: whenever disability accommodations are requested, avoid making assumptions. Encourage the parties to work with the association, legal counsel, or fair housing professionals before denying a request. Legal hotline question number 2, should buyers write personal letters to sellers? Question: a listing agent receives several offers. Some buyers include personal letters describing their families, occupations, military service, religious beliefs, or photographs. The listing agent contacts the remaining buyer's agents and asks if they would also like to submit personal letters. Is this a good practice? Answer: no. It is generally considered a poor fair housing practice. David explained that buyer love letters often reveal information relating to protected characteristics, including race, religion, familial status, national origin, disability, or other personal information that has nothing to do with the terms of the offer. Once a seller receives that information, there is a risk that the seller's decision could be influenced, intentionally or unintentionally, by factors unrelated to the purchase contract. Although buyer letters are not automatically illegal under federal law, many Arizona brokers and brokerage companies strongly discourage or prohibit them because they increase fair housing risk. The safest practice, David said, is to help your seller evaluate offers based on objective contract terms, not personal information about the buyers. Broker tip: focus negotiations on price, financing, contingencies, closing timelines, and other contractual terms. Personal information should never become part of the decision-making process. Legal hotline question number 3, reserved parking for a tenant with a disability. Question: a tenant with a mobility impairment asks for a reserved parking space near the entrance to her apartment. The apartment complex has plenty of parking, but none of the spaces are reserved. Must the landlord grant the request? Answer: in many situations, yes. David explained that the Fair Housing Act requires housing providers to make reasonable accommodations when necessary for a person with a disability to have an equal opportunity to use and enjoy their home. Providing a reserved parking space is one of the most common reasonable accommodations requested under fair housing laws. The request should be evaluated individually, but if the accommodation is reasonable and necessary, the housing provider generally should grant it. Reasonable accommodations are intended to provide equal housing opportunities, not special treatment. Each request should be evaluated based on its individual facts. Legal hotline question number 4, should you disclose a group home in the neighborhood? Question: a seller asks whether the listing should disclose that a nearby home is occupied by individuals receiving supportive services. Should the licensee disclose this information? Answer: it depends on the circumstances. David explained that fair housing laws protect individuals with disabilities from discrimination. If the home's occupants are protected by fair housing because of a disability, a licensee should be extremely cautious about making disclosures that could discourage buyers or reveal protected information. On the other hand, if a material fact unrelated to disability exists that affects the property or the transaction, Arizona disclosure laws may still require disclosure. These situations are highly fact-specific. When fair housing and disclosure laws intersect, David explained, it's often wise for the broker to seek legal guidance before deciding how to proceed. Arizona broker tip: never assume someone's medical condition or disability status. Likewise, avoid volunteering information about neighbors or occupants unless a legal duty to disclose clearly exists. When in doubt, consult your designated broker or qualified legal counsel before making the disclosure. Online discussion question 1. Why have many Arizona brokerages stopped encouraging buyer love letters during multiple offer situations? Answer: buyer letters often reveal protected class information that has nothing to do with the contract terms. This creates unnecessary fair housing risk by exposing sellers to information that could improperly influence their decisions. Question 2. Why are requests for disability accommodations evaluated differently than requests based solely on convenience? The Fair Housing Act requires housing providers to make reasonable accommodations when necessary to provide individuals with disabilities an equal opportunity to use and enjoy housing. These requests receive special legal consideration. Question: why should licensees consult their designated broker or legal counsel when fair housing and disclosure obligations appear to conflict? Answer: some situations involve competing legal duties that depend on specific facts. Consulting experienced professionals helps ensure compliance with both Arizona disclosure requirements and fair housing laws.